Hello and welcome to another episode of the Lexbe webinar series, your destination for sharp, timely, and practical guidance on e-discovery, generative AI, and digital forensics. I'm Jeff Fugit, the Chief Revenue Officer at Lexbe, and I'll be your host for today's session. Whether you're trying to admit Slack messages, Instagram DMs, cloud-based business records, or group texts from a witness's iPhone, today's session will equip you with a legal framework and practical strategies to get that evidence into the record securely, credibly, and efficiently. We'll walk you through federal rules of evidence, highlight key tactics like self-authentication and production-based authentication, and share real-world examples of how courts are ruling on these issues today. So let's dive in. Just a few quick housekeeping items here. Our webinars happen monthly and cover leading-edge issues in e-discovery, generative AI, and digital forensics. If you experience any technical issues, don't stress. Just shoot us a note to webinars@lexbe.com and we'll address those right away. We'll be sharing a recorded version, a PDF version of the slide deck, as well as a podcast version of today's session. So keep an eye out on lexbe.com and on our YouTube channel. And yes, we want your questions. Pop them into the Q&A panel and we'll answer them after today's presentation. And follow us on LinkedIn to stay up to date with our latest live and on-demand sessions. Before we meet today's featured guest, just a quick intro to Lexbe in case you're new to us. Lexbe has spent over 18 years helping legal teams win document-intensive litigation. And we do that with the most advanced Gen AI deployment in e-discovery. We have Lexbe Pilot, which is the next generation of early case assessment, and the insights it provides are really incredible. It enables you to query the entire case and get up to speed almost instantly. We have Lexbe Copilot, your Gen AI-powered assistant for case strategy and document review built into every plan at no additional cost, so you don't have to worry about tokens or context windows or anything of that nature. And then we have Lexbe Autopilot, which is automated document review for responsiveness and privilege. Lexbe is also lightning fast. We have over 10,000 CPUs that power our platform and process over 1 million documents per hour. One recent client uploaded 1.64 terabytes of PSTs and began reviewing the same day. We give you more time in your case documents so you can build a stronger case. We have a highly intuitive, user-friendly interface. We deliver the industry's fastest return on investment. We are also rated as the e-discovery company that's the easiest to do business with, a high performer, and the easiest to administer. We have a full-service forensic lab staffed with Celebrite and Magnet Axiom certified investigators. We perform remote or on-site forensic collections of smartphones, cloud accounts, social media, you name it, and we can help you with it. If you'd like a demonstration of our platform or a complimentary forensic consultation, simply email us at sales@lexbe.com. We'd love to show you how Lexbe can support your next case. All right, now let's get to the main event. We're joined by a powerhouse in litigation and digital evidence strategy, Nick Schneider. He's a partner at Eckert Siemens and a seasoned litigator in high-stakes intellectual property and commercial disputes. Nick has successfully authenticated everything from trade secrets to text messages in complex cases, and today he's here to show you how to do the same. So without further ado, I'll turn it over to Nick Schneider. Nick?
Thank you so much, Jeff, and a pleasure to be here with you all today. My name is Nick Schneider. I am a partner in the intellectual property litigation and commercial litigation groups at the national law firm Eckert Siemens here in the Boston office. And today we are going to talk about laying a foundation for ESI and specific types of ESI. We'll talk about business records, text messages, social media, emails, photos, videos, and specifically we'll talk about authentication and how at trial or an evidentiary hearing or any context where you're trying to get ESI into evidence, how to best do that. And my goal for this session is to make this informative, maybe a little fun, and most importantly, practical. I've taken exams directly from my trial outlines and hope that you can implement them directly into your trial practice. So with that, let's dive in. This is just a little information about me and some information about my firm. And if you have any questions about this program, feel free to please reach out to me. My email address is nschneider@eckertsiemens.com. Would love to hear from you. So we're going to talk about authenticating ESI. First, we should talk about what ESI is, so we know what we are dealing with. Then I want to talk broadly about how to authenticate evidence in general. Then we'll apply that to ESI and talk about different ways to authenticate ESI specifically and specific considerations. We also need to talk about self-authenticating ESI and how to do that and how that factors into your trial preparations. We'll touch on judicial notice as a means of authenticating ESI, as well as some courts, some jurisdictions consider production by the other side enough to sufficiently authenticate ESI. And then about the second half of this program, we'll look at specific examples of types of ESI and the types of foundation, lines of questioning to use to get that information in at trial. So what is ESI? I'm sure you're all very well familiar, electronically stored information. And it refers to any type of information that's created, used, or stored essentially on a computer in digital form, accessible by digital means. In my IP commercial litigation cases, this is the vast majority of the type of evidence that I'm dealing with. Evidence that's stored or created or shared on a computer or a phone or a tablet, some electronic device. So let's talk about what is authentication. Well, as I'm sure you are familiar with, if you're a litigator, there are 5 elements to laying a foundation for any piece of evidence. The OPRA elements, as I like to think of them: the original document rule, privilege, relevance, authentication, and hearsay. Today, I think it'll be most helpful to focus on authentication. That seems to be the most hotly contested of the 5 foundational elements when it comes to ESI and getting ESI at trial. There are considerations with ESI about fraud or forgery or hacking or manipulation of evidence that aren't really present with other types of tangible or other documentary evidence. So I think the focus should be on authentication. So what does the rule say? And as you'll see during this presentation, I'm often referring to the rules, and as a best practice, as a litigator, always be cognizant of what the rules provide. And you'll see with authentication, the rules are our best friend. They lay out the pathways for certain types of evidence, including ESI, and the best practices to get that evidence in a trial and authenticate it. So Rule 901A, go back to that. Rule 901A states that to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. And that's really the inquiry with authenticating evidence is this the real thing? Is this what the proponent really claims it to be? Is this the email that that person sent on this date? Is that the contract that the parties signed? Is that the text that that person received? I find it helpful to think about the purpose of the rule. Why is there an authentication requirement for laying a foundation for evidence? I think whenever you're making any kind of legal argument, it's always helpful if it's available to make an intent, purpose, or policy argument. So the purpose for authenticating evidence at trial is that the process is grounded in the concept of trustworthiness. The advisory committee notes to 901 talk about authentication as a special aspect of relevancy, and that until it's authenticated, not quite established, that the evidence is relevant. So again, broadly on authentication, is the evidence the real thing? It's shown by circumstantial evidence, testimony, and other documentary evidence, as we will see. And you should note that under Rule 104A, you're actually not bound by the rules of evidence in deciding, when the court decides, the admissibility of a piece of evidence. So we will see when we talk about the specific types of ESI that we really need to follow the roadmaps, the paths laid out in 901B, and then the set of conditions for self-authentication in Rule 902. So today we're going to really dig deep into 901B and 902. I've put together in my own practice a little cheat sheet of the ways to authenticate ESI under both 901B and 902 for self-authentication. And these are, I'm sure there are others, these I have found to be the most common ways to authenticate ESI. The ones I've bolded in particular are the ones we're really going to focus on in this presentation. You have 901B1, a witness with personal knowledge can authenticate ESI. 901B4, other circumstantial evidence can be used to show that the ESI is what you're claiming it to be. And you'll see in our example exams, sometimes we combine the two. We have someone with personal knowledge as well as circumstantial evidence. If you're dealing with a audio recording or video, you may have someone who's familiar with the voice. That's 901B5. We'll also talk about 901B9, evidence about the accuracy of a recording process. Again, that gives it that inherent or presumption of trustworthiness. Then as to self-authentication, 9025, a public authorities publication. Sometimes if a news outlet has published something online, that can be self-authenticating, as well as 9026. 902.11 and 12 deal with business records, very similar to the hearsay exception on that. 902.13 and 902.14 we will talk about, which is self-authenticating ESI by certifying that the process to collect it or how it was created was done by a means that has sufficient trustworthiness and the lack of involvement of a human, which gives it that presumption of trustworthiness. And then finally, certain types of ESI may be subject to judicial notice under 201B, where we can kind of shortcut and bypass these other rules to get evidence in. And we'll talk a little bit about that. So I want to take 901B1, 4, and 9, I think are the most common paths to authenticating ESI, and talk about what kinds of evidence would be useful to authenticate the ESI on one of those three paths. So first, 901B1, the rule says that a testimony of a witness with knowledge, personal knowledge, that an item is what it is claimed to be. So what are some examples in an ESI context? You could authenticate an email by offering the author's testimony that the author sent the email. Someone with personal knowledge of the email, yeah, that's my email, I sent it. You could authenticate a chat room transcript by offering a participant's testimony that the transcript accurately represents the exchange. You could similarly authenticate text messages by offering a participant's testimony that the transcript accurately represents the exchange. And you'll see that's kind of the buzzword when authenticating ESI by someone with personal knowledge is, does this accurately reflect what that person, that witness observed at the time? Does the photo accurately reflect the scene? Does the video accurately reflect the scene? Does the email, text message accurately reflect what was sent on that day? The concern, again, is trustworthiness. Was this manipulated at all? And then you could authenticate a social media posting by offering the testimony of a witness who, again, observed the author writing and posting the subject content. 901B4 is that circumstantial evidence. The rule is distinctive characteristics and the like, the appearance, contents, substance, internal patterns, or other distinctive characteristics of the item taken together with all the circumstances. So here, and you'll see in the examples, looking for distinctive characteristics of that email, that text message that would tie it to a particular sender. So, for example, you could authenticate an email by offering evidence that the purported author is known to use that email address listed, that the body of the email includes facts known to a small group of people, that includes the author, or the signature block at the end of the email contains the author's name. Building blocks of circumstantial evidence to prove this is the real email. It's not a product of fakery. You could then authenticate a social media posting similarly by offering evidence that the purported author previously communicated using that social media account, or that they discussed the substance of the message with others. And similarly, you could authenticate a website showing that it has distinctive features that are associated with that website or owner. And then 901B9 is evidence about a process or system, evidence describing a process or system and showing that it produces an accurate result. So here you're relying on the method of the creation of the evidence to show that it's trustworthy and not capable or susceptible to manipulation or being faked. So, for example, you can authenticate a text message by offering testimony from an e-discovery tech about how the text was collected and how that was inaccessible to users and not able to be altered. Or a social media post by offering expert testimony that the social media platform is reliable and accurately tracks account access and activity. And similarly, with a website, you could offer a printout from an archival website, something like the Wayback Machine, that inherently produces accurate results. And really, particularly in that example and underlying all of this is the idea that there's no incentive to fake or manipulate this evidence, this ESI. It was created well before litigation. There's no incentive, particularly on the part of a third party, to manipulate that evidence, and that therefore gives it that presumption of trustworthiness. So let's see what this looks like in practice. We've talked a lot about generally the rules, what they are, some examples. Let's see what this looks like actually at trial or an evidentiary hearing. So think, for example, we have a business record, a printout of some kind that we want to get into evidence, and we've got our HR director on the stand who's going to lay a foundation under 901B9 to authenticate this document. So what would that look like? Ms. Cleaver, what is your position at Stewart Consulting? I'm the Human Resources Director, laying a foundation for personal knowledge at this point. What are your responsibilities as HR Director? I write, edit, and approve our human resources policies. I'm showing you what has been marked Exhibit 25. Do you recognize this document? Yes, it's a printout of our HR policy on annual staff performance reviews. Where is this policy stored? It's stored on the company's intranet computer system so that our employees can access and review it. Who created this printout of the policy? Me. How did you do that? Again, here we're getting at the means of creation under 901B9. I used my work computer at my work desk. I went to the company policy folder, clicked on the file titled Performance Review Policy, and printed it out on the printer in my office. How long have you used the computer you used to print the policy? Since the last time we upgraded our computers about 3 years ago. When printing from your work computer, do you find that it produces an accurate result? Yes, it produces an accurate result. So there we've laid our foundation talking about the method, the creation of that that piece of evidence and provided testimony of the reliability of that method. So that's kind of authentication the old-fashioned way in a nutshell. But there's also a second path that you can go on, not just for ESI, but for all types of evidence, but particularly relevant to ESI, and that is self-authenticating the evidence. And you'll notice really what that means in the ESI context is that it's not so much self-authenticating, but pre-authenticating, and taking the effort to have someone, a certified person as the rules require, provide an affidavit, essentially pre-authenticating the ESI. So Rule 902 provides that the following items of evidence are self-authenticating. They require no extrinsic evidence of authenticity in order to be admitted. So here, again, this is by the way that they are created, these items, there is an inherent presumption of trustworthiness. So 902 lays out 14 categories of types of evidence that it considers inherently trustworthy and therefore self-authenticating. Relevant for our purposes are 902.11. This is really the business records and is actually a mirror and cites 803.6, the hearsay business exception. And then 902.13 and 902.14, which talk about electronically generated or stored records. And you'll notice that each of these three talk about certified. They all use the word certified, and that leads to a certification requirement, and is why I think of it more of a pre-authenticating than self-authenticating. So what are the certification requirements? Well, the requirement, as I alluded to, is that anyone seeking to introduce ESI must present certification in the form of a written affidavit sufficient to establish authenticity as if the information was provided by a witness at trial. So it's really, you're laying a foundation by affidavit. Must be done by a qualified person. I typically advise my clients to engage an IT person, either in-house to them or an e-discovery specialist who can testify as to the method of collecting text messages or emails. If you're doing a forensic collection of someone's email account, you would want that person to be able to put in an affidavit to cover the certification requirements. Although the rules don't define qualified person, but in my experience, that person is certainly the most qualified. If you can't get evidence in the self-authentication path, of course, you can still get evidence in through the 901B pass, the old-fashioned way. In fact, there are some courts that decline to recognize human-generated digital content like social media posts or emails, even if they technically might fall under 902.13 for self-authenticating digitally created ESI. Some courts take the view that an individual still inputted that information and therefore is still subject to manipulation. An alternative way to get evidence in through authentication is judicial notice. And judicial notice under 201B provides that there are certain kinds of facts that the court may just take as trustworthy without question. And the rule provides that the court may judicially notice a fact that is not subject to reasonable dispute because it is generally known within the court's territorial jurisdiction or can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. So typical types of ESI that can be judicially noticed are government websites, if you're referring to electronic orders or docket entries on a court, not even in your case, in any case, things that are posted on an online docket or any government website, SEC filings, for example, all I think can be judicially noticed. Things like maps and geographic data can be judicially noticed. I was recently fighting a third-party subpoena to my client in federal court, and as you know, the requirements are compliance must be within 100 miles of where the party resides or their principal place of business is, and I used Google Maps to show that my client was outside of 100 miles of the desired place of compliance, and the court could take judicial notice of that. Calendar info, timeanddate.com, I use all the time to calculate if someone was late in a filing or responding to anything. That can be judicially noticed. And then the Wayback Machine archived website showing how a party's website changed over time, how they were marketing themselves, stuff I use all the time that under 201B I think can be bypassed, shortcut the authentication process. And then finally, some courts take the view, and there's really three different approaches that courts take, that the fact that an opposing party has produced ESI, that may constitute a concession as to its authenticity. Now, based on this, I like to put in all my discovery responses, the production of a document doesn't constitute an admission as to its relevance, authenticity, hearsay, its admissibility at trial. But some courts, and again, it bears noting that authentication obviously is one of the 5 factors, and it's necessary but not sufficient, obviously, to getting ESI in a trial. You still will have to show that it's relevant, assuage any hearsay concerns. So courts take 3 different approaches to authentication by production. Some courts have found that a party producing ESI discovery implicitly concedes that it's authentic. Other courts have found that a party concedes authenticity only where the party produces ESI in response to a specific request for production. If you can tie it to a specific request that it's responsive to. And then some courts consider the fact that a party produced it as one of several factors in determining whether the ESI has been authenticated. But it certainly, under any of these 3 approaches, is relevant, the fact that another party produces. So I always, in all my discovery requests, specifically ask for ESI. Obviously, you want to ask for it to be produced in native format and provide any specifics on how you would like the ESI, but I always include in my definitions and even in my specific requests all documents and ESI concerning whatever, so that ESI is being produced. So let's now talk about specific types of evidence and the various ways to get those in at trial. First, let's talk about photographs. And photographs have a long history of being introduced as evidence in court. The Supreme Court considered the first type of photograph almost 200 years ago, now getting up there, 1859. The paths to authenticate photos should be no surprise. It's what we've been talking about today. 901B1, someone with personal knowledge. 901B4, circumstantial evidence. 901B9, the accuracy of the recording process. And then, depending on the source of the photo, potentially judicial notice. So let's look at how we would authenticate a photo under 901B1, someone with personal knowledge. And there's really 2 ways to do it. You could put the photographer on the stand. You could put a person who is at the scene who could testify that the photo fairly and accurately reflects the relevant scene as seen by the witness. And that, you'll see, is the through line in all these exams for laying foundation is, does the ESI fairly and accurately reflect what was actually there that day. So let's see how we would lay a foundation, what our exam would look like for both a photographer and someone at the scene. So first, let's put our photographer on the stand. Where were you on the night of the fire? I was walking my dog around the block of my neighborhood. When did you arrive at the house on fire? It was around 8:13 p.m. What did you do when you saw the house on fire? I pulled out my cell phone and started taking photos. Do you recognize what has been marked Exhibit 14? Yes, it is one of the photos I took on my cell phone of the house on fire. Does Exhibit 14 fairly and accurately depict the scene as it appeared on the night of the fire? Again, there are those buzzwords. Yes, it does. How would we do that if there was a witness to the scene? Imagine we can't get the photographer for whatever reason, unavailable to testify, but we found someone who was there that night and saw the fire. Where were you on the night of the fire? I was at home sitting on my couch in my living room watching TV when I saw the fire at my neighbor's house across the street. How long have you lived in your current house? 19 years. Mr. Chris, do you recognize what has been marked Exhibit 14? Yes, that is a photo of my neighbor's house across the street from my house while it was on fire. Does that photo fairly and accurately depict the scene as it appeared on the night of the fire? Yes, it does. So there we have authenticated through either the photographer or a witness, someone with personal knowledge that can testify to the accuracy of that photo and that it reflects what the scene looked like on that day. And as you'll see, depending on the type of evidence, laying this foundation is not that complicated. If you have someone with personal knowledge, it can be simply a handful of questions and likely won't even elicit an objection from the other side. But so what if you have a situation where, with videos, a lot more common than photos, where you have no witness, someone with personal knowledge to the scene. You have no witness and there's no videographer. Imagine you have a security camera. And so you'll see that authenticating videos is similar to photos, the paths laid out. With videos, it could be a little different than photos because videos are more often subject to manipulation, editing out. If you're dealing with security camera footage, maybe you have hours and hours of footage that you want to edit or present in a particular way. In that case, you may need to call the person who did that editing to talk about that process and lend that trustworthiness to it. But so imagine we're dealing with security camera footage. There's no witness to the scene. There's no videographer. And we want to get this video in at trial. Well, I think we would use 901B9 for the accuracy of the recording process and walk through what that is. So what would that look like at trial? Mr. Williams, can you identify what has been marked as Exhibit 23? Yes, that is a DVD containing a video from our security camera system in our warehouse. When was the video made? The date of the incident. How do you know that? The security camera system has a date and time generator that automatically puts the date and time on the recorded footage. Who made this DVD? I did. How did you do that? I searched our file system for the video file for this date and time and copied it onto the DVD. So you'll see a lot of an important aspect of the 901B9 inquiry is kind of a chain of custody inquiry of what was the method by how this was created and how this ended up here in front of the fact finder or jury in a jury trial, a judge in a bench trial. What is that chain of custody? So continuing our exam, is this DVD an accurate reproduction of that digital file? Yes. How do you know that? I watched both the files from the network and on the DVD to make sure they were the same. Mr. Williams, can you please describe the security camera system in your warehouse? Yes. A video camera is mounted in the upper southeast corner of the warehouse where the wall and the ceiling intersect. The camera is in a fixed position pointed at the warehouse floor. The camera records the footage to a DVR unit located in a locked cabinet in our IT manager's office. Footage is stored in our system for years after it is recorded. So again, there, and obviously this is your witness, you would prep the witness to talk about this system and the aspects of why it is trustworthy. Talk about how it's locked in a cabinet, no one has access to it, there's no chance for it to be manipulated. Does the security camera system produce an accurate result? Yes, it does. So that's videos. Let's talk about authenticating emails. In my commercial litigation practice, emails are probably the most prevalent type of information that I'm dealing with. And the paths to authenticate emails are very similar, 901B1, B4, B9, and then there's potential to self-authenticate through 902, 11, and 12 business records, or 902, 13, and 14 about generating an accurate result. As we discussed, just because an email is produced by the other side doesn't mean it's automatically admissible. Some courts may treat it as authenticated, but of course venues still have to deal with hearsay. And one of the principal logistical problems with emails is that they often consist of long chains of emails, which means you might have to authenticate and lay a foundation for every email in the chain. It's not often, at least in my practice, that a single email is, of course, it's important, but it's in context of a chain of responses that really gives its persuasive power. So authenticating emails under 901B1, personal knowledge of a witness, and B4, circumstantial evidence, distinctive characteristics, include, as we've touched on, identifying the email addresses, special language, non-public information, things that would link it to that sender or the author, a correlation of emails with a timeline that establishes the events. If the email speaks of a certain thing happening at or around the time, that could tie it. You could have testimony of the sender, some with personal knowledge, any attachments that help identify the sender, and then, of course, any metadata embedded in the email that could trace it to that sender. And here, really, you're concerned about an objection to authentication of someone saying, that email's fake. I didn't send that email. That's not the email that I sent. So you're trying to tie it to that particular sender, presumably the opposing party. So what would this look like at trial under 901B1 and B4? I think it's effective to combine the two. Mr. Loon, can you please identify what has been marked as Exhibit 7? Yes, it's a printout of a chain of emails I sent and received. Where are these electronic records stored? On my company's computer system. Mr. Loon, I direct your attention to the email in the middle of the page bearing the date and time of Monday, April 9, 2020 at 11:22 a.m. Who sent that email? I did. Who did you send it to? To Jim Wilson. How do you know that you sent it to Mr. Wilson? The to line in the header has Jim's name and email address. How do you know that email address is Mr. Wilson's? I've sent him emails before and received email responses, and we've talked on the phone about emails we have sent each other from that address. So again, there you have someone with personal knowledge of sending this email, as well as circumstantial evidence tying that recipient to the email. I direct your attention to the first email on the next page, bearing the date and time of Monday, April 9, 2020 at 12:02 p.m. Who sent that email? Jim sent that email to me. How do you know that Mr. Wilson sent that email? He starts off the email saying, in response to your email below, and his name and email address is in the from line, and his signature box shows his name, address, and telephone number. What system do you use for sending and receiving emails? Gmail. So here gets into a little 901B9 as well. And you can stack these paths to make sure there's no question about authentication. So asked about what's the system for sending and receiving emails. Gmail. In your experience, does Gmail produce a reliable result? Yes, it does. Let's talk now about text messages. And as I'm sure you all are well familiar with, texts are becoming more and more common form of communication and sometimes critical form of communication. Think about it. If you are communicating with someone over text versus sitting down and writing a letter or even an email to someone, there's a different level of formality there, and I find that people are typically put less thought into text messages, and our texts are therefore more likely to reveal certain things that someone wouldn't reveal if they sat down and wrote out an email or a letter. And for that reason, texts are becoming more and more critical types of evidence. Think about here in Massachusetts a few years ago, we had that Michelle Carter texting suicide trial where they had thousands of text messages back and forth. The whole case was built on text. The Anthony Weiner sexting trial, the Amber Heard, Johnny Depp trial had text messages as an element. Texts are generally obtained as screenshots or as photos of the text messages. I've done it both ways, where I've had an e-discovery specialist do a forensic collection of a cell phone versus having the client press the two buttons on the side of the phone and take a screenshot of it. I've found that the latter is more user-friendly for a fact finder. Of course, I love working with e-discovery specialists and having them do forensic collections, and I think it's great with emails, texts. I've seen it'll spit out the text in kind of each individual text is an individual document where you really get the effect of it as a chain. So I instruct my clients to take that screenshot, kind of take a photo of the text, try to, if possible, get the name of the person or phone number in the text, the time and date. I know it's not always possible to get that information, but that'll help place it in context. So very similar to emails, we have our various paths to authenticate text messages, and let's see what that looks like in practice. So authenticating through, again, we're going to try 901B1 and B4, and it's a two-step process with text messages, particularly under 901B1. Is a witness with personal knowledge must testify that the screenshot printouts of the text accurately reflect the content of the text message. And then a witness with personal knowledge must provide testimony establishing the identity of the purported sender of the text message. And that comes in 901B4, the distinctive characteristics of that text message. Records can sometimes be obtained from phone companies to support authentication, but they can vary, and I have found they're not the most reliable, and I'm not sure which phone companies actually store or make available the substance of a text message. Maybe they can tell you the date and time a text was sent, but I found in my experience phone companies to not be the most helpful in that regard. So let's see what this looks like at trial. Mr. Brandy, can you please identify what has been marked as Exhibit 42? Yes, it is a printout of a screenshot of a text chain. Do you recognize this text chain? Yes, I do. How do you recognize this text chain? This is a text chain between me and Luke Carter from my phone. Who made this printout? That is Exhibit 21. I did. How did you make the printout? Again, this was getting to that chain of custody type inquiry. I took a screenshot on my phone of the text chain, downloaded it, and printed it out for my attorney. Did you alter this text chain in any way? No, I did not. Does this screenshot accurately reflect the text message chain between you and Mr. Carter? Yes, It does. Now we'll get into that 901B4 path a little bit. Directing your attention to the middle of the first page where it says November 2, 10:31 p.m. And then has a message in gray reading, "Hey big guy, I got the green," with a 4-leaf clover emoji. Who sent that message? Luke sent that message to me. How do you know Luke sent that message? Because Luke's name appears on the top of the text bubble. Also, I know his phone number to be the one listed. He's always also using emojis in his messages, and he always refers to me as the big guy for some reason. And after I got this text from Luke, he called me and talked to me about his pickup from his deal. So all circumstantial evidence to tie the sender of that message to Luke Hart. So that's text messages. Let's touch briefly on social media. And you'll see it's similar but has some nuances. Those are our familiar paths. Social media evidence, like text, is becoming increasingly prevalent in a way that people communicate. Facebook, YouTube, Instagram, TikTok, you name the social media platform. Recall that Murdaugh murder trial, that Snapchat video from the Sun, I think was critical evidence to placing him at the scene of the crime. Like text messages, there are two authentication issues for social media, and they're similar. Whether the printout is genuine, that chain of custody inquiry accurately reflects the post, and whether the post can be attributed to that particular person. Here, unlike text messages, social media, what do you always hear when a tweet or a post doesn't go the way the person hoped it would? Oh, I was hacked. I got hacked. That wasn't me. That was a hacker. Social media, you have to think about hacking as a potential excuse to authentication and ways to get around that. And again, like a text, attributing a post or a message to a particular author is the same kind of circumstantial evidence. You can match up a username or get at dispelling any notion of hacking by talking about how secure the password is and other information. So let's see what this looks like at trial. Imagine we have a criminal case where we are refuting a criminal alibi. Someone claims I wasn't at the scene of the crime. Well, imagine we're the prosecution, and let's tie that criminal defendant, to the scene of the crime. What were you doing on the night of July 2nd, 2019? I wanted to go out, so I checked to see what friends were around and wanted to hang out. Who did you reach out to? I hit up a few friends, including Jimmy. How did you contact the defendant? I went onto his Instagram account and checked his stories. Why'd you do that? Because Jimmy never answers his cell phone when he's out, and he's trying to be an influencer type, so he's always posting to Instagram and his stories when he's out at a club or bar. Which account did you visit on Instagram? I visited the username Jimmy Green Socks. Why did you go to that account? Because it's Jimmy's account. How do you know that? Because he told me that it's his account. He added me as a follower. He sent me direct messages through his account that we've talked about in person. He also has his birthday listed, and he's always posting photos of his kids too. Besides the defendant, does anyone else have access to his password? Not that I know of. Has the defendant ever complained of being hacked? No, he hasn't. Not even when I complained about my Instagram account being hacked. When you looked at the defendant's Instagram on July 2nd, what did you see? I saw him post several stories at a club in downtown Boston we go to all the time. He was taking shots and dancing on the dance floor. And that's the same club where a shooting later occurred in which the defendant has been charged? I believe so. Yes. So there we started to get into the substance of the evidence. You would likely move for admission of the evidence before getting into the substance, but you can see why that type of evidence would be useful after it's been authenticated. And then we'll conclude today's program with discussing authenticating websites or posts on websites. Here are the paths to authenticating websites, and you'll notice there are a few additions for self-authenticating through newspapers, periodicals, things that have a presumption of trustworthiness. Websites are a very important type of evidence. Think, for example, a commercial fraud case, how the defendant was marketing themselves or holding themselves out to be as experts in a particular type of technology or industry or market can be highly relevant to a commercial case. Courts generally trust the reliability of the technology, but must often be shown that the website at a certain URL shows that it was accurately reflects at the time, because websites aren't static, they're often changing. This is when using the Wayback Machine or some other technology to capture a website at a particular time. We at my firm use a program called Page Vault where we capture that information. It can be very helpful. So what would this look like at trial, getting in a website? What is the basis for your statement that Acme Advertising held themselves out as Google ad marketing experts? It was posted on Acme's website, which was at acmeads.com. How do you know that was Acme's website? It had their logo, business address, phone number, and social media links. Anything else? Yes, when I was looking for advertising services, I visited the website and submitted a service request through their website, which they responded to. So there is a short exam for authenticating websites, and that will conclude this program today.
Thanks so much, Nick. Fantastic insights, examples, and real-world takeaways. As I mentioned in the introduction, Lexbe has an advanced digital forensics lab staffed with Cellebrite and Magnet Axiom certified investigators. We perform remote and on-site collections and have performed collections from all kinds of sources, as you can see from this partial list. If you need to find deleted text messages, hyperlinked files, web pages, or collect data from sources like Slack or Microsoft Teams, then we're here to help. Our forensic experts also document the chain of custody and testify to support evidence authentication. If you have a forensic project and would like a complimentary forensic consultation, simply let us know in the comments or on the survey at the end of today's session. At Lexbe, we're also leading the industry with Gen AI-powered e-discovery solutions. This includes Lexbe Copilot, which is your document review and case strategy assistant. I'll speak more about how you can use it to help with authentication on the next slide. Lexbe Copilot is included in all Lexbe plans at no additional cost, so you don't have to worry about tokens, context windows, or Lexbe Autopilot, which is automated document review for responsiveness and privilege. We've seen it outperform human reviewers, delivering great precision and recall scores. Plaintiff firms love this for their document-intensive cases, and in-house legal departments love it for third-party subpoenas and to help achieve litigation readiness. We price this per document with a setup fee. And then there's Lexbe Pilot, which is the next generation of early case assessment. It is incredibly powerful in equipping attorneys with a comprehensive understanding of the case and the hot documents in short order. One of the great use cases of this is to actually take the complaint and look at the claims and see if there are specific documents in the case that support those claims. So Lexbe Copilot. Here are some of the Lexbe Copilot use cases. There are really virtually unlimited number of use cases because you can simply ask it any questions that you might have about the documents you're reviewing. It does a great job of analyzing financial records and identifying transactions, summarizing medical records as shown on the image that's to the right of the screen there. Also summarizing depositions and much, much more. It is engineered to be a human-in-the-loop assistant, meaning it works for you and you provide it with the guidance via prompts. To help you in that process, it also comes with a multitude of pre-engineered prompts that make it easy. When it comes to assisting with authentication, Lexbe Copilot does a great job of analyzing metadata and hash values. It can generate authentication roadmaps based on the federal rules of evidence, and it is excellent at cross-referencing deposition and testimony to help validate ESI. If you'd like a demonstration of Lexbe's Gen AI-powered e-discovery platform, simply let us know at the end of today's session in the survey or in the GoToWebinar Q&A console. We'll get that scheduled for you. Now let's tie those ideas back to how Lexbe helps legal teams. Jordan Howlett is a sophisticated litigator running a multi-office boutique firm. Most of his cases involve larger, well-funded opposition. With Lexbe, he likes having the Gen AI integration available at his fingertips so he can quickly gain insights into the relevant case documents. David Jones was concerned he would be outgunned by his AmLaw opposition. He quickly realized that Lexbe was a great equalizer and helped him build his best case that delivered a winning verdict. Paige Tackett at Thompson Co. needed Lexbe's speed to get some productions out the door to meet deadlines. Lexbe is lightning fast, and as I mentioned before, we process over 1 million documents an hour, which gets you from document ingestion to productions faster. That brings us to the end of today's webinar. On behalf of the entire Lexbe team and our guest speaker, Nick Schneider, thank you for joining us for this deep dive into the foundation of digital evidence. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. And please take a moment to complete the short survey that's about to pop up. Your feedback helps us make each session better than the last. Be sure to follow Lexbe on LinkedIn so you'll be alerted to the latest podcast and webinar episodes, and watch your inbox for an invite to our next webinar on best practices in e-discovery, Gen AI, and digital forensics. Take care.